evening, everyone. My name is Russell Blair. I'm Director of Education and Communications at the State FOI Commission. It's great to be here. I appreciate everyone who's here in person, who's here virtually. Really want to make this an opportunity to answer any questions that you have about FOI. Particularly, I know we have a lot of board and commission members as it pertains to meetings. That's really what we're going to focus on today. There is some stuff on records I'll probably touch on at the end. For the folks in the room, if you have questions as we're going, feel free to raise your hand and I can call on you. I'll try to save some time at the end for people on the screen because sometimes that just gets a little more difficult. But we could go through questions from people online, at the end. And really, in the hour or so we're here, going through the material. Just want to give you a comfort level. And, I understand that most people who serve on boards and commissions, a lot of times you're not an attorney, maybe you're an expert in a certain area, you care a lot about the parks and you're on Parks and Rec, you care a lot about conservation, you're on a conservation commission, and maybe you get appointed and then all of a sudden they throw this book at you and it's got FOI and Robert's rules and your head is spinning and you're going, oh my God, what did I sign up for? And really we want to make you all feel comfortable and also to know when it's okay to ask questions. And that's really today, tomorrow, in the future. I was just telling the first selectman, the most important thing you might learn is my contact information. You could always email me or call me if something comes up. Inevitably it will, and even sometimes a 2 or 3 minute phone call with me may make you feel a lot more comfortable before you send that agenda in or whatever it is. So want to really make sure everyone's comfortable and answer any questions. One second here, there we go. Whenever I do one of these presentations, I always start off by talking a little bit about the history of the Freedom of Information Act. Just because I think it's important we all kind of understand, why do we have this law? What does it cover? What is it all about? And this year is actually a special year for FOI, and that is because we're celebrating the 50th anniversary of the law. So if you didn't know, the FOI law passed back in 1975. Ella Grasso was the governor at the time. You see her photo there on the screen. She was a real champion of open government in Connecticut, and she actually, when she ran for governor, she made passage of the Freedom of Information Act part of her platform. So, other states have open records laws. Connecticut is not unique in that. But one thing that is a little bit unique about Connecticut is that we have a Freedom of Information Commission. And what that means is that really citizens of Connecticut, they have a strong mechanism to make sure that people are doing things in the open, are doing things transparently. Anybody out there, it could be a citizen, it could be an attorney, it could be town employees, they can make requests for public records. There's laws that govern public meetings that we'll talk about, about agendas, executive sessions, minutes, and so on. And if anybody out there thinks that something hasn't been done appropriately, they can file a complaint with our commission and they don't have to pay for an attorney. We have attorneys who are state employees who investigate those complaints. That's the only thing our commission does. We're probably one of the smallest state agencies. I think we're right now about 16 employees. And the only thing we do is we investigate alleged FOI violations across the state. We get in the neighborhood of 700 to 800 complaints a year between local and state, so we're quite busy. And we have all kinds of powers to hold hearings if necessary. So if there was an issue with your board and somebody filed a complaint, depending on what happens, board members may have to go to hearings in Hartford and talk about, why did you think it was okay to do that in executive session, or was there something on an agenda and it wasn't worded appropriately and somebody thought that it was misleading. There's different things that people can challenge, but really at the end of the day it's about doing your work in public. If you conduct your business in public, if you follow the rules, make sure your agendas get posted in time, your minutes get posted in time, there's generally not much you have to worry about. We'll talk about some of the more difficult things like executive session. That's always something that can be difficult, trying to figure out what you can do in an executive session, what that means. And also we'll talk about what is a meeting, because I think that's really important too. We think of meetings often as we're sitting here, we're at the table, we're at our meetings, but we also have to be careful and mindful of how we communicate with fellow board members, because a meeting, as you'll see when we go through this, it's not just when we get together once a month to meet. It can be other things like text messages and emails and discussions, out at the grocery store. So, we'll talk about kind of where the line is there and how to how to make sure that we're doing things correctly. So some basics about the FOI law. As I said, there's 2 parts of the law. It guarantees public access to meetings, and it allows people to request records of public agencies. I think it's important to sort of clarify a couple of things that are not part of the law. One is public comment. We get a lot of questions about public comment at meetings. There's no requirement under FOI or any other state law to have public comment. That's not that we don't encourage it. I think it's a good thing to have, you know, at your boards and commissions, if members, you know, members of the public want to come, they want to address something. But the FOI law doesn't give the public the right to speak at a meeting. It's about attending the meeting. So anybody can attend a public meeting. They can't be excluded. You know, it doesn't matter who they are. It doesn't matter if they live in the town. It doesn't matter if they have any business before the board. You know, public meetings are open to the public, but the boards can decide if they want to have public comment and how they want to govern that. You know, very commonly, if somebody wants to speak at public comment, you might ask them to step forward and say their name and address. You can't ask somebody their name and address to come to a meeting. If they come to the meeting, they can sit there. They're not required to sign in. They don't have to say who they are. They're allowed to just observe a meeting. If you want to have public comment, you can set the rules. You could set time limits. You could set topical limits. You know, some towns I've seen, they ask will people only address items on the agenda. Some towns, you know, you can talk about whatever you want, but you want to get 3 minutes. You know, so public comment is not part of our law. And records requests, I just think it's important, you know, you know, we'll talk a little bit about that, you know, at the end, but, you know, basically under the Freedom of Information Act, people are allowed to request copies of public records that you keep, that you maintain. So if you're on a board or commission, the only FOI requests you're responsible for are anything that, you know, you've received as a commissioner or a board member. So maybe correspondence that you've received, you know, packets and materials that you get for your board meetings, you know, those types of things. You know, just because you know, are on a board or commission, you're not responsible for all the records of the town. If somebody wants, you know, police records, they go to the police commissioner or the police department. If somebody wants, you know, Parks and Rec, they go to Park and Rec, or they go to the Park and Rec Commission. So you're only sort of responsible for your kind of universe of records. And then the commission, question.
Yeah, quick question. So if I'm taking notes at a commission meeting?
So there is an exemption, you know, under the law, there are certain things that are exempted. And there is an exemption for preliminary drafts and notes. So what I always tell people is, if you're at a meeting and you're taking personal notes for your own recollection as a memory aid to help you remember, I think something like that would probably be exempt under that provision. However, if you are in a meeting and you go back to your computer at night and you type up a long email and you start sending it to everybody about what happened or what you're thinking about something, that's a little bit different, because I think it's kind of not really a note anymore now that it's being disseminated. Or if it's something that is, you know, going to be part of some other proposal or project, but, you know, personal notes I think would probably be exempted. So they're a public record, but you might not have to disclose them depending on the content.
Okay, but a personal email summarizing the meeting could be.
Yes, yeah, because I think the difference there is that you're transmitting it to somebody, whereas a personal note is you're keeping it to yourself, you know, as your own, you know, your own thoughts about something, you know, what you might want to bring up or what you might decide later on.
Thank you.
The question about public comment, my experience is that public comment is usually part of what ends up in the transcript of a public hearing, and therefore that would be disclosed.
Yeah, so you would have to, you know, if you, like in a transcript from a public hearing or minutes of the meeting, it might reflect public comment. And there are some instances where you have to have public comment, like planning and zoning on certain things. But at your, you know, if you're the Board of Selectmen meeting and you have your monthly public comment, or, you know, if you do it twice a month or however you do it, that is up to you whether you do it or not. And every town does it a little bit differently. You know, some will do it at one meeting of the month, not the other. Some will have topical limits and so on. But yes, if you had a transcript or something, that's a public record, somebody could request. In the Freedom of Information Commission, we already talked about, you know, we are sort of the umpires that come in and settle disputes that arise. You know, sometimes people ask, well, what can happen, you know, if there's a complaint filed against us? You know, the commission has different powers to try to find a remedy to correct the situation. You know, if minutes were not done and they still hadn't been done by the time a complaint was filed, we might order you to create minutes. You know, the strongest thing we can do though with meetings, and I always say this as a word of caution, not because this is going to necessarily happen, but the commission has the power to nullify votes taken at a meeting. So if there was a situation where, you know, something major was voted on and the agenda wasn't proper, or certain people weren't allowed into the meeting, this is something where, you know, I always tell people to keep in mind, think about the rooms your meetings are in. If you're having a really hot issue and there's a lot of people that are coming out, We have to obey the fire code, but we also have to obey FOI. And if you tell somebody, hey, sorry, you can't come to this meeting because there's too many people, that person could file a complaint and they would have grounds, to file a complaint, and the commission could potentially, find a violation. And just to give an example, yeah, so I grew up in Chester, not far from here, and maybe, it might now be 15 years ago, there was this issue with roosters in town. And somebody had the idea, they wanted to have a proposal to, I think it was to ban roosters through some ordinance or something. And people came out in support of the roosters, and they had these chicken hats, and it was on Channel 3 News, became this big, big thing. And the biggest meeting room in the town hall couldn't accommodate all the people, so they had to move it to our elementary school, and they had to hold it in the gym because it was the only place big enough to put out all the chairs and everything. So just be thinking about that. If you get to a really contentious meeting, there's people packed in the hallway, and the fire marshal's giving you the eye or whatever. The best thing to do would be to try to, say, well, we can't do it tonight. We're gonna schedule a special meeting, or we're gonna do it at our next meeting, or we're gonna move to an alternate location, because that would be an issue if somebody can't get access. Again, you're not gonna break the fire code, but you have to weigh that with people have the right to be there for a meeting. Okay, so what is a public agency? I mostly just include this to sort of explain a little bit about, who is covered by the law. Sometimes people ask about that. So for towns, it's really, it's quite simple. You don't have to read the whole thing there, but any board, commission, all your town departments, sometimes individuals, the first selectman can be a public agency, a school superintendent can be a public agency. One important thing to keep in mind is things like subcommittees, task force, working group. Generally speaking, if you create a committee and you assign people to it and you give them a specific charge, and they are essentially kind of carrying out the work of your group, chances are that's probably going to be a public agency. So certainly all your subcommittees. Sometimes other groups it's a little bit more difficult and the details really depend. But to give an example, we had a case recently where it was the town of New Fairfield, and they're having this big dispute about where they want to locate their school bus lot, because nobody wants it in their neighborhood because of all the traffic. So they're trying to find a new location, and they're running into all this opposition. So the first selectman, the school superintendent, the board of ed chair, they put this group together, and they said, well, it's not a commission or a committee, right? It's just all of us are getting together. But because they're making this decision about where this school bus lot is going to be, and because it's such a big issue in the town, recently our commission ruled that that group should have been having a public meeting all along. So, if you create different groups, if you create a, committee to oversee the high school renovation or something like that, those are probably going to be groups that need to follow FOIA as well. Generally does not apply to businesses or nonprofits. The most common exception with nonprofits is a library. If you have a library board that's elected or appointed by the first selectman, that might be a public agency under FOI, even though the library itself might be, a nonprofit sort of as their status. All right, so meetings. The first thing I want to talk about with a meeting is what is the definition of a meeting? And it's important, so we'll spend a little bit of time on this. And the way I try to explain it is there's kind of three things. And if these three sort of conditions are met, then it's a meeting under FOI, whether you agree or not. There's a definition in the law, and that's what we have to go by. So the first thing is, meeting means any hearing or proceeding of a public agency, any convening or assembly of a quorum of a multi-member public agency. So quorum is really very, very important in FOI. If you don't know what a quorum is, it's a voting majority of your board. So if you have a 5-member board, your quorum is 3. You have a 7-member board, your quorum is 4, and so on. I think the commission used to look at meetings more broadly, but we had a case that went to the Supreme Court and the commission lost, and the judges looked at that definition and said, well, quorum is one of the key elements. So what that means is, generally speaking, if you were not a quorum of a board, if 2 board members of a 5-member board want to discuss something, that's okay. If they run into each other at the grocery store and they want to talk about what's happening, that's okay, because it's 2 of 5, it's not a quorum. If a 3rd member wanders down the frozen food aisle and sees them, and now 3 of them are talking, then we have a problem. There are some exceptions to that we'll talk about. There's things like caucuses, and there are some limited abilities where that wouldn't matter. If they were all 3 Democrats together at the grocery store, they could say it was a caucus, and that wouldn't count as a meeting. But the general thing to keep in mind is quorum is really, really important when we look at FOI and the definition of a meeting. So sometimes what that means is between meetings, if you're on a big board, there's 9 members, and you wanna divvy up the work, and these two people are gonna go do this, and these three people are gonna go talk to the guy in Clinton and see what they're doing, and these two people wanna do this. Those kind of things are okay, because ultimately all those people are gonna have to come back to the board and report out what they're doing, and then there's gonna be some sort of voter decision by the board. So that's the difference between sort of, sometimes people call them working groups, or I call it, doing your homework between board meetings. In small groups, less than a quorum, that is okay, but you can't have your entire board be doing that, if all the members are meeting at Dunkin' Donuts to talk about something, that would be a problem, yes.
Is the threshold for a quorum of 50%, or is it as defined?
It's 50% plus one, so like if you had six, it would have to be four. It's enough, basically, it's enough people to carry a vote. So if you had a 6-member board and you only had 3 votes, you wouldn't be able to pass something.
Okay, and do you have to differentiate between alternates and members, or?
So I get that question a lot, and I always tell people, I would consider the alternates when you're counting that, because you never know who's gonna sit on something at a given meeting, and if you say, well, we've got 2 members and 2 alternates, and who cares? What if those 2 alternates end up being the people that have to make the decision at the meeting? It could just get a little bit messy there. So the first thing is a quorum. The second thing about a meeting is, convening or assembly. So obviously when you're together and you're talking, but also, a communication by or to a quorum of a multi-member public agency, whether in person or by means of electronic equipment. And this is where we have to be careful about things like email and text message. So what that means is if there is an email message among a quorum of board members, and the third thing, so quorum, is the first part. The second part is convening or assembly or communication, and the third part is discussing or acting upon a matter of which they have supervision, control, jurisdiction, or advisory power. For shorthand, I call that board business. So if a majority of board members are emailing about board business, that is, by definition, is a meeting under FOI. And by definition, it's probably gonna be, what we would consider an unnoticed meeting, because if it's in your email inbox, there's no agenda, there's no public notice, the public can't attend. And then, the question I get a lot of times from people is, well, we're not voting on anything, we're just talking about stuff. But if you look at the definition of a meeting there, to discuss or act. So even if you're not voting on things, if a majority of your board is talking about upcoming things, decisions they're gonna make, weighing in on something, what they might, do at a future meeting, and that's happening over email, that's happening over text message, that could be a problem. If somebody learned of that, they could file a complaint and they could allege, look, that was a meeting of the Planning and Zoning Commission, even if it was happening over email, even if it was happening over text message. And as I said, there are some exceptions to this, that we'll talk about in a minute. That there is one, for example, about a social gathering. So if you're at a social event or some other town function, that doesn't automatically make it a meeting just because you're gathered there, but the rules still apply that you shouldn't be discussing your board business. So, the example I like to use is, if a high school football team makes the playoffs and you want to go to the game and you want to support them, you might have the board event. They all might be there. They should not be talking about the school budget when they're sitting in the bleachers at the football game. And sometimes that's, could be appealing because you're like, hey, we're all together right now. Why don't we just start talking about what we're going to do at the next meeting? But obviously there's no public notice. The public can't hear the discussions. And that may impact, even if you don't vote, it may impact what happens at a future meeting. So does anyone have any questions on that, about the definition of a meeting and kind of where the line is?
You just mentioned about notices of meetings,
Mhm.
public hearings. Those are publicly disclosed, I think, in Old Saybrook. It comes out on for instance, the planning commission, it's on their webpage.
Yeah.
It says when their meetings are, so somebody has to go on there and look to see if that, but.
Yeah. We'll talk about the notice requirements, but generally, people either have to look on the website, they've got to go to the town clerk's office, mostly everything in FOI, minutes, agendas, special meeting notices, it's all gonna go through the town clerk's office. So it's important that you make sure, when you're submitting your agendas and everything, it's getting to the town clerk, it's getting posted. Because the obligation is on the board or the commission. If a complaint comes in, it's gonna go against the board or commission. It's not gonna go against the town clerk if the town clerk, didn't post it. So if you are sending agendas, particularly if you're, on a tight time frame, like you're trying to, we'll talk about the timelines later, but if you're sending something right before town hall closes, it might be good to pick up the phone and call the town clerk's office and make sure, that they get it and they get it posted, because if it doesn't get posted, ultimately it falls on the board or commission. It's not the staff, it's not the town clerk or whoever, whoever was the person who didn't do it.
Is it required that postings have to be, like, for instance, in newspapers also, or is that?
Not under FOI. There are other statutes that require newspaper postings. A lot of it has to do with town meetings, a lot of it has to do with land use boards, planning and zoning, and so on, charter revisions and things like that, if you have a charter. The routine meetings don't need to be posted in the newspaper.
Are you gonna talk about caucuses?
Yeah, we'll talk about that. So a couple other general things on meetings. We already talked about this. Anyone can attend a public meeting. There's no required sign-in sheet. They don't have to give their name. You can set your own rules for public comment. Any public meeting can be photographed, recorded, or broadcast. So I like to say, I would hope you're not saying anything in a public meeting you wouldn't want recorded, but just, keep in mind, somebody in the audience could be recording you. They don't have to ask for prior permission or anything like that. They can't do it in a way that's obstructive. They can't be leaning over the dais with their phone in your face or something, but if they're sitting in the audience and they've got their phone out recording, that's okay. And we'll talk more about agendas in a second, but I just think it's important that when you're preparing agendas, remember the agenda is really an important tool for the public to decide whether or not to attend the meeting. So you may know all the business of your board, you may know exactly what's going on, but when you're looking at the agendas, just keep in mind, there may be people out there who are not as familiar and they're just trying to look at this and figure out what's happening. One example I like to give of, what not to do, there was a Board of Education on the other side of the state, and they had an agenda and there was an item on there that said facilities update. Sounds pretty boring, right? Well, they actually voted to close an elementary school, which is probably one of the most significant things you can do in a town. And the agenda said facilities update. So clearly, they didn't get a lot of parents coming out. They got a lot of angry parents when they saw the vote, and they actually, because there was so much public blowback, they reversed the decision and the school is still open. And there were a couple FOI complaints filed about that. So just keep that in mind when you're putting your agendas out there. It's really for the benefit of the public to understand. We talked about this kind of already, email and meetings. Just be careful with the back and forth emails. If it's administrative, you guys have to schedule a meeting and you say, hey, when are people available? Or somebody says, hey, our regular meeting in July is not going to work for me, I'm on vacation. Those kind of things are okay. But if it's really the debate over the issues, the discussion of the what the board is going to do, voting on matters, you can't do that over email. In the corporate world, everyone, groans and says, oh my God, this meeting could have been an email. In FOI world, it's sort of the opposite. And it's, oh my God, this email should have been a meeting. So just be careful with emails and text messages. Next we'll talk about the requirements for noticing public meetings. And the way I like to try to explain this is by going through the two different types of meetings most common. There is a third emergency meeting I'll touch on in a second, but generally you're going to have regular meetings and special meetings. So regular meetings every year, usually towards the end of the year, you'll prepare a regular meeting schedule, and that needs to get filed with your town clerk. And those are your regular meetings for the year. You were going to meet the second Thursday of every month at town hall at 7 o'clock, whatever it may be. Those are regular meetings. And a special meeting is just any meeting that is outside of your regular meeting schedule. So the name is a little bit misleading, especially for people who are new to this, because they think special meeting and they ask, oh, can we do this? Can we do that? There's no restrictions on what you can do at a special meeting, save for one. You cannot add items to the agenda under new business at a special meeting. But what is on the agenda, it can be anything. So it could be that, regular meeting had to get moved and you just kind of copy and paste. It could be that there's some issue came up between meetings and you want to have a special meeting to deal with it. So, topically, you're not limited. The only limit is you can't add items to the agenda, during a special meeting. So for regular meetings, make sure your agendas get filed with the town clerk at least 24 hours in advance. Is your town hall closed on Friday?
No.
Okay, so you don't have to worry about this, but sometimes it's impacted with holidays. Just keep in mind the days the town hall is open and closed, because you can't file an agenda if town hall is closed. So if
It is closed this Friday.
this Friday, okay, yeah, so July 4th. So if you have a Monday board meeting, make sure you get your agenda in, Thursday, because Friday it's too late. So it needs to be filed at least 24 hours before the meeting. Someone had asked about the website, so it's kind of interesting. The municipalities get a pretty big break with websites. Technically, you do not have to post your agendas for your regular meetings on the town website. Now, most every town does it. I would really encourage you to do it, because if people don't see an agenda on the website the morning of the meeting, they get concerned, and sometimes they call me and they say, oh my God, what's going on? Should I file an FOI complaint? And I have to tell them, well, did you check with the town clerk? The same thing happens all the time with minutes too. They don't see the minutes on the website. They think they don't exist. So try to get your agendas on the website, but if you have a special meeting, it absolutely has to get on the website. So anytime there's a special meeting, goes to the town clerk 24 hours before, like the regular meeting. But special meetings have to get posted on the website because they're not on the regular meeting schedule, so it's sort of additional notice, additional heads up to people. A regular meeting, you can add new business by a 2/3 vote, so if you have, things that come up, before, after the agenda gets put out, or something happens the morning of the meeting, or a member wants to add something to the agenda, you can do that at a regular meeting. Just make sure you have the 2/3 vote, take a vote to add the item. You can discuss the item, you could vote on the item if you needed to. You can't do that at a special meeting. We'll talk more about the content of minutes in a second. But the filing timeline, regular meeting, you need to file your minutes within 7 calendar days. And special meeting, you have to file your minutes within 7 business days. So I don't know why they made that distinction. It, to me, doesn't really make sense. I usually just tell people 7 days if they ask, but if you have a special meeting, you have a little bit more time to get your minutes done in that case.
Quick question. So regular meeting, and I assume it's a bad idea at a regular meeting to say, I move to add an item to the agenda, let's close the elementary school.
Yeah, I think that's a bad idea.
Yeah.
Technically, you could do it.
Right.
There wouldn't be anything against that, but something like that, I think would be very frowned upon. And I would hope something like that, you wouldn't get 2/3 of your board to support it. I would hope the board members would say, wait a second, this is a significant thing. Oftentimes where I see things that get added, something was inadvertently left off, or, your board of selectmen meets Monday night and something blew up Monday morning,
Yeah.
and you need to deal with
Yeah, we
it.
do it.
There was a town once where they had called me because they were asking about an emergency meeting, and it kind of worked out because they had a meeting that night, but they had gotten an inspection report on a dam back from Deep, and Deep told them the dam was at imminent risk of failure, and they had to move some money around to hire somebody to do some work to shore it up. So they did it because they had a meeting that night, they just added it, but that was something, when we talk about emergency meetings, I said, well, if the state is telling you gotta do something, that might have been a case where they could have had an emergency meeting to vote on something.
And I imagine under special meetings, new business is a bad agenda item.
Yes, yeah, I would, if you're doing agendas, I would just say, take off the new business, because, inadvertently, somebody's gonna say, oh, new business, we have any new business, and so, yeah, if you're doing special meetings, you could just delete that item, and then it removes that from being an issue.
Quick question, minutes must be filed, those are draft minutes.
Yeah,
I've
so-
seen this debate where, we always vote to approve the minutes, and somebody goes to amend the minutes, and some are like, whoa, you
Yeah,
can't change
is
it
that
now.
do you mind holding off for a second, because I have a minute slide, and I'll talk about that.
Okay.
Yeah, no, there's not really a right or a wrong way to do it. I'll explain to you kind of what I feel is the best way to do it, and we'll certainly talk about that.
Okay, thank you.
So the last type of meeting is an emergency meeting. This should be rare, only in the case of a bona fide emergency, and really the key thing here is that you cannot wait 24 hours. Something has happened, you can't wait to schedule a special meeting, because remember, special meeting, all you have to do is file a notice with the town clerk, it's posted on the website. So, something happens, you can meet the next day if you need to. So this is if it's really in those rare cases where you can't wait, and there's no notice or agenda requirement for an emergency meeting. You can only consider emergency matters, and the minutes of the meeting need to be filed within 72 hours of the meeting. They have to be posted online, and they have to state the reason for the emergency. There was a case involving an emergency meeting in the town of Ridgefield that went all the way to our state Supreme Court. And they gave us some helpful language where they said, it needs to be a situation that's unexpected, demands immediate action, such that it makes it impossible to give 24 hours notice of a meeting. They had a personnel issue involving their fire chief, and they had an emergency meeting to deal with the fire chief, and that was the case where the Supreme Court said, there was no need to do that. They could have put the fire chief on leave and had a meeting to deal with it later. They did not need to have this emergency meeting to deal with, the conduct of the fire chief. So this is some of the exceptions. or exemptions to the meeting requirements. So, we were talking earlier about the rules for meetings. Well, there are some cases where you could have a quorum of your board discussing or, meeting or other public agencies meeting, and it's not considered a public meeting under FOI. The first is a personnel search committee for an executive level employee. So what this means is, if you had your school board and they were searching for a new superintendent, they could create a search committee. And I've seen this happen. Sometimes the board will appoint itself as the search committee. And
We're
they can
doing
do
that right now with
Yeah.
the police chief.
Police chief, yep. So your police commission could say the search committee is us, the police commission. And they can meet outside of public view without agenda requirements, without having to take minutes and all that, while they're conducting the work as a search committee. However, the only thing a search committee is supposed to do is, review candidates, work with a consultant, come up with names of people. They can't pick the person. Picking the person needs to be done at a public meeting. It needs to be on the agenda. There needs to be public notice and so on. But, essentially it allows them to not have to schedule a meeting every single time they want to interview somebody, or every single time they want to review resumes, or they want to work with a search consultant. So that is an exception. There's an exception for strategy or negotiation sessions related to collective bargaining. What this means, for example, is, if the union president wanted to sit down with the whole board of selectmen to talk about where things were with the contract or something like that, they could do that. Or if a quorum of the Board of Education wanted to, meet with the union people about a school contract, they can do that. They can't vote on the contract, it's not approving a contract, it's strategy or negotiations. I'll talk about caucuses last, because that usually generates a lot of questions. So a staff meeting of a public agency, this just means if the first selectman calls a meeting of, department heads, it's not a public meeting. Chance and social meetings, this is the football game, this is the holiday party, when a quorum of a board is together, but it's not meant for, being you're not there to discuss business. One thing to be careful of with that is, either sort of pre or post meetings, you can't be sitting around in the parking lot after the meeting, talking, about what was voted on, or talking about what's gonna happen at the next meeting. Imagine you have a contentious planning and zoning application, it gets continued, the developer, walks out and sees the whole planning and zoning commission talking in the parking lot, that he or she could file a complaint and say, I don't know what they were talking about, but, they just, they continued my application, and now they're all out there chit-chatting. So, that's one of those things where, it may be that you're not even talking about anything wrong, but just be careful of the appearance, especially if people see people huddling right before or after a meeting. I think some people get suspicious. And caucuses. So a caucus is, by definition under FOI, it's a gathering when it's all members of the same board and the same political party. Doesn't matter how many there are. So if you have, Republicans are the majority on a board, they can all gather as just Republicans, and if under the definition in the FOI Act, it would be a caucus. And the only way the law defines a caucus is who is in it. It does not limit what you can talk about. So, what that means is potentially, you can be talking about the substantive decisions you're gonna make. You could be talking about the town budget in a caucus. You could be talking about hiring the next police chief in a caucus. There's not a limit on what you talk about. It's about who is there. And a couple of things to keep in mind. It is the same board, so you cannot be bringing in, the majority of the Board of Selectmen and the majority of the Board of Finance and say, oh, well, everyone's a Republican, so it's a caucus. You can't be caucusing, back and forth between, between boards, or, you can't invite in the Republican or Democratic chairperson of the town committee if they're not part of that same board, because, oh, it's a caucus, it's political. Caucuses under FOI are a little bit different than I think sometimes what we think of when we think of a caucus, where we're nominating candidates or something like that. So just keep that in mind. So people ask, can we have an email caucus? Can we have a text message caucus? Yeah, you can do all that as Republicans or Democrats. You can email, you can text message, doesn't matter how many people are there. But if you add somebody from the other party, that would be an issue, then now you're in a meeting, if it's a majority of the board.
How about if you're unaffiliated?
So if you're unaffiliated, the way that the law works is, technically, you have to register with the town clerk for who you're gonna caucus with. I think a lot of people, if they're unaffiliated and they run on one ticket or the other, they just kind of, look, I ran on the Republican ticket, I'm unaffiliated, I'm part of the Republican caucus. Really legally, you're supposed to register. So that would mean the Republicans would say our caucus for the term is, we three Republicans, and then this person was unaffiliated, but we endorsed them, so they're gonna be part of our team, so to speak. The reason is that you're not supposed to bounce back and forth, because if you're, if you ran on a Republican ticket, you're gonna caucus with them, or, if you were like a petitioning candidate or a third party, you could pick which group you wanted to caucus with. Maybe there's a Green Party person and they say, I want to caucus with the Democrats. So if you're not a majority party, you can pick which side you're gonna go with, but there should be a registration. It really would just be like, you could just write it out and give it to the town clerk to reflect that.
Once you choose, the first time you choose and you register, then you
Yes,
belong
yeah.
to that for the rest of the term.
Yes, it's for the term that you're serving. There was a case involving, believe it or not, a library board that gave me a major headache about that, because it was somebody who, they ran with one ticket and then they got elected, and then they didn't like those people and they wanted to go with the other side, and we looked into all this, and I said, no, you can't go back and forth. You could just say, I'm not gonna be part of any caucus, I guess, but you couldn't, be with one and then decide to go with the other.
So if we have a commission meeting here and there's a big vote, and maybe we don't vote, can we immediately transition to a caucus in the parking lot within the party?
As long as it's the people, the people are correct, that it's all of the members of the same political party, yeah, there's no, it's not like you have to notice a caucus, you don't have to, there's no limitations or anything like that, so it's really, it can be abused, and I'm sure in some places it kind of is, one of the examples I give is, you have some towns or cities where they elect people by district, like New Haven, the Board of Alders. They have, I think, 20 alders, they're, I think, all Democrats, basically. They could say, all us 20 alders, we're all Democrats, we're gonna have a caucus before the meeting. When I was a reporter, I covered the Hartford City Council occasionally. They would basically conduct all their business in caucus, and the meetings were just kind of for show. And the first time I went to a meeting, I was so confused because there was like no discussion. And I, as a reporter, I worked at the Record Journal, I covered the town of Wallingford, they'd have these long meetings in 3 hours, and the Hartford City Council meeting, it's like half an hour. And I was like, what's going on? And then one of the other reporters told me, well, it's because they're in the caucus room is when they're really deciding everything. The public thing is just kind of for show, so.
So that is legal.
It's legal, yeah. I mean, I think it's frowned upon. I don't think it's transparent, but if you had, or the other thing I've seen sometimes, unfortunately, is, you have 3-member boards of selectmen, you might have 2 people of one party, and they just leave the third person totally out of it, and they make all the decisions and decide everything in caucus. They get to the meetings, and the poor third person is asking questions about what's going on because they have no idea. So it can be abused sometimes, but, it's legal as a caucus.
Quick question with regard to, let's say, Board of Finance, can they invite ex officio in or not?
So, if you're ex officio, then you can participate in a caucus. So I know in, some towns, the board, the first selectman's ex officio on boards and commissions, so
Yes.
that means the first selectman could be part of a caucus, could be part of a meeting, an executive session, in those cases.
Do they have to be with the same party?
I think they would have to be, yeah, because the caucus definition is the same party. So if you had if you had an unusual situation where, there was like a Democratic Board of Finance and a Republican first selectman, then I don't think the Republican first.
What we have.
Okay, yeah, so I don't think,
You mentioned that.
I don't think that you could then go to a Board of Finance caucus, because it's all, they could invite you into, I think, to an executive session if there was one for some reason. I don't know if there would be a Board of Finance, but, yeah, no, it's an interesting question, but yeah, if they're ex officio, I had to look into this recently for somebody, they can participate. But if it's a different party, I don't think that they could in the caucus.
But they couldn't if they're a different party, okay.
Right, yeah, I think that, because the caucus is really defined by the people in the
Right.
party, it's very.
Okay.
All right, so minutes. So what has to go into the minutes? Really, the minutes are meant to be the record of the vote, so you want to make sure to record all the votes. Also, what commissioners were in attendance at the meeting. And if you have an executive session, you need to list who attended the executive session besides the board members. One thing that's important, when recording votes, is you need to take the minutes in such a way that people can tell how the members voted. So if it's a 7-2 vote, you could say the 2 nays and then list them, or you could list every member and put yes or no, or however you want to do it. But if it's a split vote, you don't want to just put the numerical, because the minutes say it's the recording of the vote of each member. If it's unanimous, you don't have to put in, then you just say unanimous, as long as you've listed who's in attendance. So this goes to your question about the minutes that need to be available in the draft and all that. So, minutes need to be made available within 7 days of the meeting. They, need to get filed in the town clerk's office. They don't necessarily have to be posted on the website within 7 days. They have to be filed in the town clerk's office. So inevitably, what you submit are gonna be draft minutes probably, because you're not gonna meet again to approve them. So what I have told folks is, you know, you can, if you want, if it makes people feel more comfortable, you could put draft, you could put subject to approval, whatever you wanna call them, you can put on there something like that as a disclaimer, but those are basically the minutes of that meeting. And I think the best way to handle it is put them on the agenda for the next meeting for adoption. And then if you wanna make revisions, you discuss the revisions at that next meeting, you vote on the changes that you're gonna make. And then what I would suggest is you make the changes in the minutes of that meeting and you reflect it in the, you know, when those minutes get published. And now I do get questions from people who say, well, you know, what about the other minutes that are already on the website or whatever? Now, and this is where I say there's not a right or a wrong way to do it, but I think it could be a tremendous amount of work if you're going back every single time, especially if there's not changes or not significant changes, to then require the town clerk to go back and repost the minutes just to say approve. Look, if there's a major error or a significant change, then I think you use your discretion and you could say to the town clerk, hey, we need to really repost the May minutes because we made a lot of revisions at the June meeting. You could discuss that and see if it makes sense, but I don't think you have to go back every single time, especially if it's clerical changes.
Okay.
And if you put on there, subject to approval, then, it's kind of a heads up to people, all right, these are not, haven't been approved yet, they can look to the next one in the book, and they can see if there were any changes that were made.
So actually, I do the minutes for the Board of Selectmen, it's just easier sometimes and I send them, I do them, and I say, guys, how does this look? And somebody might say, actually, I said blah, blah, blah at the meeting, and I'll add it, and then, is that okay?
I think you wanna be careful, cause even something as mundane as changes to the minutes. I think that's why you see it on a lot of agendas. I think if you're looking for proofreading, if it's, not significant changes, or there's not a debate about it, I don't think it's as big of an issue, but if it's something, I've seen this before, unfortunately, where like, there's arguments about, what was said or what wasn't said, if it's something like that, I think that would be.
Not that, never.
Yeah, then I don't think there's a problem, for having somebody kind of eyeball it to make sure it's accurate. Because then if there is if there need to be further changes that are made, you could always put it on the agenda for the next meeting, and there could be discussion then. Okay, so does that answer your question?
Yes, thank you.
Yeah, I got into a long back and forth argument with somebody in Old Lyme about this, who was insistent that, how can I post these, and, didn't wanna post it, and I was like, no, you have to have the minutes within 7 days, so, if you wanna say draft, you could put draft. And that, then you can, if there's big changes, you could always repost them. Yes,
It doesn't seem like we have too much of a running dialogue in the minutes. It's usually, we discussed this topic, the board discussed this topic. So-and-so motion, made a motion, seconded, all in favor.
yeah, that's fine. I mean,
That's usually the way it goes.
yeah,
It's not
minutes are
like-
not meant to be a recreation of the meeting, it doesn't need to be a transcript. When you do public comment at your meetings, you don't have to list every single point that everybody made, you don't even have to list the people if you don't want to, you could just say, 15 people spoke at public comment. Or sometimes I've seen people do, 10 people spoke in favor, 3 spoke against. The minutes, really, the key thing is the votes, you gotta have the votes. Who the attendance, and then executive session, who went to executive session, the town attorney went in, the first selectman went in. I think brevity is good in minutes, the key thing is getting them in on time, that's the most important part. So if the question is like more content versus getting them in, you gotta get them in, that's the most important, the timeliness and the minutes is really key.
Well, maybe you mentioned this, so you're going to, like, are recordings required?
No, only for certain virtual meetings, but I'll talk about that. So that's a good segue. So electronic and remote meetings that, I'm not gonna go through all this. If you wanna know more, look on our website. We have a thing called our remote meetings primer. A couple basic things. It's your choice if you wanna do in-person, remote, or hybrid meetings. It's up to you. There's not a requirement that you do it. I think a lot of people got used to it during COVID. I think there are some benefits to doing a hybrid meeting. You might get more participation from the public, and some commissioners probably like it. If they're traveling, they can still participate. But there are some towns that have just gone back fully in person. The couple of key things, if you have a online, meeting, meeting with online access, the agenda is still 24 hours, but at least 48 hours before the meeting, the instructions to attend electronically need to be available on the website. So generally, that's gonna be the Zoom link, or however you're gonna have people access it. So, that is 48, the agenda is still 24. When you prepare the agenda, you should also put the link on the agenda. If you get the agenda out 48 hours ahead of time with the link, then you're all set. But if something is, you're still working on the agenda, then just make sure, on the website for your board or on the calendar somewhere, that Zoom link is there. The reason for that is that probably that won't come up all that often, but there are some provisions in there about if people don't have access to technology or there's technical questions, it gives them more time to try to sort that out. However, you can still do a special meeting electronically on 24 hours notice, so it doesn't change anything for special meetings. The only meetings you have to record under FOI is if you do an online only meeting. So for some reason, one of your boards is meeting entirely virtually. It's a little bit more uncommon now. I think most people are in hybrid or in person, but maybe you have a subcommittee or something, and they want to meet virtually, or, maybe you want to schedule your January meeting to be virtual, so you don't worry about snow. If you had a regular meeting that was virtual, then you would have to record it. Post the recording on the website within 7 days, and it has to remain available on your website for at least 45 days. So any other meeting, like today, how we're doing hybrid, if this was a public meeting, you wouldn't have to record this. I know a lot of towns do and post them, and I think it's a good practice, and I think there's a lot of good benefits to that. But under FOI, the requirement only kicks in if it's entirely virtual. The reason being, if something is not working entirely virtually, there's no in-person option. I always tell people, members of the public who, grumble about this sometimes, well, if you're having technology issues, and you can always go in your car and go to the meeting, right? If it's only a virtual, recording it, make sure that there is a record of it if something goes haywire, and that will be available, it has to be up for at least 45 days.
I'd like to talk to you about that after.
Sure, yeah. You still do minutes for virtual meetings, even if there's a full recording. If there's a full recording, the minutes might be even shorter, right? Because you could always just put a link to the recording. You can kick people out of an online meeting if they're being disruptive, the same rules that apply to in-person meetings. The last one, I forgot to put it on here, but I get a lot of questions about it. Board members can always participate remotely. That they have that right in the statute, in the remote meeting statute. It says that if you're a member of a board, and you want to participate in a meeting remotely, you're allowed to do that. So they can't force a, person, if somebody wants to have remote access, the board has to accommodate that, whether it's Zoom, whether it's calling in on a speakerphone or something like that. They can participate, even if it's an in-person meeting, they can call in or they could Zoom into that meeting.
What about executive session?
And remote participation?
Yeah, if you have one member that's remote, and you go into executive session, does that person have to be included?
I would think so. Technically, how to do it technically might be a little bit of a challenge. I suppose, if the way you do it, like, if you're meeting in this room and the public is out in the hallway, and they're on the speakerphone, you could probably do it that way. It gets a little bit harder sometimes with Zoom and executive session and trying to figure out that. But, yeah, if the board members have the right to participate, I don't think you could, exclude them from an executive session because they're not in person. I think you'd have to try to find a way to accommodate that, whether it's somebody calls them on the phone or something like that.
The concern that I've seen come up is, that you don't have a control over who might be in a room with.
Yeah, the environment that
The
they're in
environment
or
that
something.
they're
Yeah, no, I can understand that, but I think you'd have to just try to, hope the board member could find somewhere private, even if they're in the home or something, could they go into a different room or something for a minute, to try to avoid, something being out there, publicly that isn't supposed to be. Okay, so speaking of that executive session, this is the last thing I want to touch on with meetings, and then we'll talk a little bit about a couple of things with public records that might be relevant to your work on the boards and commissions. So an executive session, what is executive session? Well, basically, executive session is part of a public meeting where you kind of get special permission to talk about something behind closed doors without the public being there to listen. And, what I tell people is, we'll go through the reasons, But if you're kind of having to do mental gymnastics to argue that something falls under executive session, it probably doesn't. It should be pretty clear, either it's an executive session item, or it's not an executive session item. Executive session is not about, talking about things that are controversial or having difficult conversations, or, we want to sort of talk about something privately before we have to, roll it out publicly. As we go through these, I think that you will recognize a lot of times it's almost to the benefit of the town that you talk about the things in executive session. Like what I mean by that is that, there's an executive session permission for pending claims or litigation. It would be very difficult for the town to be in court with somebody when they have to talk publicly about their litigation strategy. So I think you'll kind of see that as we go through these. It's really kind of, there's sort of a larger benefit, not just the board members. It's not about avoiding difficult conversations. So the first one is personnel matters. So personnel matters means that you're, talking about issues concerning, the appointment, the employment, performance, the evaluation, the health, or the dismissal of either a public employee or a public officer. So that can include fellow board members. So that means things like, appointing somebody to the board, the conduct of a board member, if a board member had to leave the board for a health reason and they wanted to talk with their members at a meeting, that could be an executive session that they could talk about that without having to reveal it publicly. However, if you're having a personnel matter executive session, you need to notify the individual who's being discussed. So, let's use the example. Let's say you have a fire commission and you have a fire chief. And, the fire chief is not doing a great job and the fire commission thinks, hey, we might not want to, we might want to part ways with the fire chief. We want to have a conversation with him or her about that. They would have to notify the fire chief because the right of the public employee under FOI is that they can say, no, I don't want you talking about me in a private executive session. I'm going to force your hand and you're going to have to talk about this publicly. This doesn't happen all that often, but sometimes if somebody thinks, they're being railroaded, they're being accused of something they didn't do, they want it in public so the media can be there, so their supporters can be there, their family, their friends, whatever. If the person that you're discussing says, I want this in public, then it's not an option. You have to do it in public. If they don't request that, then you do it in executive session. It's up to you whether they are invited or not. And you have you can limit them, you can bring them in, ask them questions and say, all right, we're done. So with our fire chief example, if the fire chief doesn't demand the open session, they can bring the fire chief in, ask him or her questions, and then say, all right, you go wait, now we're gonna talk about what we're gonna do. So the right of the employee is not to be in the executive session, it's to have it heard in open session if they wish. The second item, pending claims or litigation, this could be a lawsuit's been filed, an FOI complaint has been filed. It could be that the board is considering taking some kind of legal action. The key thing there is pending, it's not prospective, it's not hypothetical. So it's not an open invitation for, free flowing legal discussion. There needs to be sort of something, either a claim that has been made, you've received a notice to sue, there's a case in court, something like that. You can discuss security matters in an executive session if you're concerned that publicity would, sort of affect the security issue. We see this a lot at boards of education, if they're talking about very specific school security elements, they got a grant to install cameras and they want to talk about where the cameras are going to go or something like that. That might be a reason to do an executive session. You can have an executive session as a municipality to discuss the sale or lease of property before an offer has been made. And the reason for that is sort of like security. If there's concern that publicity would impact the price, maybe there's a piece of vacant land in town that's been sitting for a while. You guys are looking for a new site for some recreation fields and you're considering putting an offer in, you may not want to have all this attention or notice out there that the town is about to put a bid in, because then somebody else comes along and, makes an offer and now you're in a bidding war for this piece of property that was vacant for months. There was no interest in it. And then the last one for executive session is you can discuss any records that are exempt from FOI. The biggest one where this comes into play probably for you will be attorney-client privilege. So what that means is if you get communications from the town attorney, a legal memo, a legal opinion, you're asking questions and you're getting responses from the town attorney, you can go into an executive session with the town attorney to talk about whatever it is. And that doesn't have to be tied to a specific case. So if there's just a general legal question, the best way to handle it under FOIA would be to ask your town attorney to prepare some sort of recommendations or their analysis, and then you can go into executive session with your town attorney to go through that. You should not use pending claims or litigation if there's not a pending claim or litigation. I see a lot of people do that just because they say, well, it's the attorney, it's legal. But the way to do it would really be that you're discussing, you know, an attorney-client memo or something like that, about a certain topic. You have to have a 2/3 vote to go into executive session, so make sure that you take that vote and you note it in the minutes. You can't vote on anything during executive session, it's really just discussion. And, you can invite in any staff that you need to assist you, so you could bring the first selectman, you could bring a department head, you could bring the town attorney. But don't create a second audience, don't bring people in there if they don't need to be in there, if you don't need to ask them questions, if you don't need that, to bounce an idea off of them, if you don't need them to hear your idea and give a response. They should not be there. And the last thing on executive session, before I take any questions, is just when you're preparing agendas, if you know ahead of time you're gonna have an executive session, I think you should list it on the agenda. You don't have to technically at a meeting if something came up and the members wanted to go into executive session, they could take a vote, even if it wasn't on the agenda, they'd have to state the reason publicly. It'd have to be one of these, applicable reasons. But if you know ahead of time, put it on the agenda and try to be specific on the topic. And what I mean is avoid things like executive session personnel or executive session legal. There's case law from the FOI commission upheld by the courts that it needs to be more than that, because again, agendas, the standard, that the courts have set is they need to fairly apprise the public of what is to be discussed. So just saying, executive session personnel, that doesn't really tell us anything. You could say, executive session to discuss performance issues in the public works department. Executive session to discuss the performance of the high school principal. You don't have to necessarily identify the person. In some cases you might, if it's a high profile thing. Things that were involved with your police chief, I imagine there were agendas where they just said it's the chief, right? Because everyone kind of knew. But if it was an individual officer, you might just say, the police commission is going to discuss the performance of a patrolman. That doesn't identify the person. So I don't think you have to go so far as to identify, an individual public works employee, but you also don't want to just say personnel because that's so vague. Personnel could be hiring, firing, dismissal, what does it mean?
Well, principal of high school is pretty specific.
Yeah, well, again, it depends, it might be, I think if it's I think, there's not really a fine line, but I think the more of import the person is, kind of, I think there's more of an expectation that, that you're gonna be more specific, but, question.
Just to review, when you go into executive session, who leaves the room?
So how you do it is kind of up to you, but really, the executive session is meant really just for the board members.
Okay.
So, I get the question sometimes about like recording secretaries. I mean, I think technically even the recording secretary, should be there and really, there shouldn't be a need to take notes or minutes of the executive session because if you do that, you've created public records. And one important thing to know, and this applies to caucuses as well, the executive session in the caucus, it's a permission to meet in a certain way. It is not to say that everything that happens in there is private. Now, I know most people think of executive session as kind of like it's private, it's not gonna get out. But if you're in an executive session and you go back home and you type up an email and you send it to somebody about everything that happened in the executive session, that's a public record. There's no privilege of the executive session in the FOI. Well, the privilege is really just that the board members are counting on each other not to violate that trust. So executive session is really predicated on trust. There's not a legal repercussion. If you talk about what happened in executive session, there's no legal recourse. You can't get sued, you can't get arrested, there's no legal penalty. Obviously, your board members will be very upset with you and you lose trust in them and they may not, want you to serve anymore or something like that, but there's no, there's nothing that sort of codifies that.
So we don't take minutes and the recording secretary does not have to be there.
No, the recording secretary does not have to be there. When we talked about exemptions and personal notes, that might be something where if you're taking personal notes of the executive session for yourself, those are probably exempted under FOI. But if you start to, share thoughts about the executive session over email and stuff like that,
Right.
it gets a little dicey.
If an executive session is going to have, because of the subject matter, many executive session meetings, don't you have to have like an outline of what was spoken at the previous executive session to keep everybody rolling along, so to speak?
I would, again, I would be cautious about creating any, if your intent is for people not to find out about what is happening in the executive session, I would be careful about how you memorialize it. I think the best way is personal notes, if you take your own personal notes. I've also seen in some situations, where sometimes things get passed out and then they get collected at the end. Because if you start writing down everything that's happening in the executive session, and that gets distributed to people, it can be, that may be a public record. This is not an executive session, but to give an example, we had a case involving the Avon police chief where there was an employee at the police department who was really concerned about the conduct of the chief. And she started keeping this log of all the stuff he was doing. And it turned out that that log sort of contributed to the chief's dismissal. And that employee at the time that she was taking all these notes, didn't think that this was something that was going to be a public record, but because it became part of this chain of events that led to the dismissal of the police chief, that was kind of one of the key pieces of evidence, it was a public record. So I would just be careful about, personal notes is one thing. If you start to share with other people and email back and forth and, create documents, it could be a little bit different, so. All right, so just a couple things on records, and then I'll take any last questions people have. What is a public record? So the definition of a public record under FOI is really quite broad. The best way to explain it is it's relating to the conduct of the public's business. Any recorded data or information relating to the conduct of the public's business. So anything relating to the work of your board or commission, correspondence that you receive from members of the public regarding the work of your board and commission, all the packets that you get, any information you receive from department heads or town officials, those are public records. And doesn't matter the format, electronic, hard copy. And one thing I think is really important to understand is if you look at that definition, nowhere on there does it say anything about the device the record exists on, and that is because it doesn't matter. So what that means is if you use your personal email for your board or commission, which a lot of people do, the emails that you send or receive pertaining to board business are still public records. So it's not off limits because, oh, it's on my Gmail account. Some people have asked me, well, oh my God, I don't want people to know my email or whatever. If that's a concern, you can always create a new email, create a Gmail account, bobsmithpnz@gmail.com, use that or something. And it's not part of the FOI law, but there also are records retention statutes. So just keep that in mind. If you're sending and receiving emails and text messages pertaining to board business, there's also a period that those are supposed to be retained. And for emails, generally, if it's not a transitory email, I believe it's 2 years as they're supposed to be kept. So if you're conducting business over email, you're conducting business over text message, be mindful that those, somebody can make those requests for those records. It doesn't mean they get to go through your phone, but it means, somebody could ask for texts between the Board of Finance chair and the first selectman. And the first selectman maybe has a town phone, the Board of Finance chair might use his or her own phone. It doesn't matter, that chair would have to go through their device and see if they had any messages that were responsive to the request. So there's no prohibition on using personal devices, but if you use them, the records you create, messages you send, messages you receive, depending on the content, could be public records. So public records are it's very much based on the content. If you had 2 members of the board that were texting pictures of their grandkids back and forth, those are not public records because they don't deal with the business of the board. So it's not that, every time you use your personal device, it becomes sort of part of this, public record universe, but if it's pertaining to public business, that is where, there could be an issue. And, yes.
So if I'm receiving email, if the board is receiving emails from the town, we all have to keep.
So if it's something where there's
like, I'd like to rely on the town, they're sending it.
Yeah, if it's something where there's like multiple versions of something or multiple people are receiving it, I don't think there'd be an issue there. Presumably somebody is like if somebody sends an email to, let's say you're in planning and zoning and somebody sends an email to the planner and they copy the commission or something on it, the planner's probably keeping those, they're gonna probably be more abreast of that. But if you're discussing things with, even correspondence you receive from members of the public, that really should be retained. If somebody contacts you as a board or commission member about an issue, and how you do it is up to you. Some boards and commissions, you might file your correspondence somewhere, right? So maybe, those get forwarded and they get saved somewhere, however it's done. But you just have to be aware that, those are records that need to be retained. How it's retained is a little bit more up to the town. Yeah, so that's really the last thing. A lot of this is more nuanced about public records and things you're probably not gonna be too, dealing with, specifically with FOI requests. If you receive them, one thing I'll say, if you get an FOI request, make sure you acknowledge it. So even though maybe you won't be the one fulfilling it, if somebody contacts you, just make sure either you or somebody else responds to them, because if you don't respond to an FOI request within 4 business days, that is considered a denial. So, if somebody writes to the, the chair of the Board of Education and makes an FOI request for, documents the board received, somebody needs to respond. It might not be the chair, maybe the superintendent responds, or maybe, whoever it is, the town attorney responds, the board attorney. So it's not, who responds is not important, but, it's important that somebody responds. So if you get something that is an FOI request, which is really just any request for records, make sure that it gets responded to. With a lot of FOI, the process is kind of left up to you how you do it. You have to follow the law, but internally how you do it, it's different from town to town. So you may have an internal way to handle it, and that's okay. But just make sure that you understand, as a board or commission member, you're obligated under FOI to provide records the same as a town employee. The records you have are probably far fewer than what the town employees have, so most of the requests probably go to the town. But particularly correspondence, sometimes that's something that comes up. Somebody may contact you and ask for, copy of correspondence. Maybe there's a meeting and you talk about a letter you received from somebody. Somebody might FOI you, hey, I want a copy of the letter you referenced, at the meeting or something like that.
Just so I understand the process correctly, if Fred, who wanted some information from the Parks and Rec Commission, he would file an FOI request with your department?
No, the requests go to the individuals who have the
The
records.
individual, okay,
Yeah.
so Fred would send something to the chairperson, Susan, for example?
Yeah, the chairperson of park, or it could be the Parks and Rec director, that comes to me.
Okay.
Yeah, so it's interesting because, yeah, so technically, there's a court case out in Greenwich where legally, people are supposed to make the request to the actual custodian of the record. So when you get those requests, you could tell the person, hey, you're nice and you're helping people. But if you wanted to, you could tell them, no, you have to contact the, whoever it was. The case in Greenwich, it was the first selectman and the law department, and even though they worked very closely together, because the problem is that if you forward it to the Parks and Rec director, then, the issue is that, maybe you can, but if they don't want to give it to the, then now we're in this dispute where you got the request, you sent it to Parks and Rec, and now Parks and Rec is saying no, and it's sort of a murky thing, but, generally, if somebody sends it, where to forward it to, try to be helpful, but if you don't have any idea, somebody contacts you and it's a state thing or something, you could tell them, hey, that was DEP, we weren't involved, you've got to contact DEP. You're not required to go across towns or across, to state agencies to get records. You're really only responsible for, for the records that you keep, the records that you maintain. They're sort of in your universe. Yes.
Well, for most boards and commissions, isn't that just the minutes and agendas?
The other thing would be all the stuff you get in the packet, any communications that you have.
What packet?
Well, like for, if you have a meeting and you get like backup material
Okay.
for with the agenda, like you get copies of site plans or something if you're on P and Z. You get copies of the budget if you're on Board of Finance or whatever the worksheets you get. Those are the records. The most common thing I see requested of board members, it's usually correspondence. That's the thing people usually ask for. They want messages between board members. There was a decision that was made and somebody wants to they think they're gonna find out what happened in the background. It's another reason to, try to limit conducting your business over email and text messages. If you're concerned about, discussions being public, well, if it happens over email or text message, it's almost certainly gonna be public if somebody FOIs it. If you, pick up the phone and call somebody, there's not a record of that, so it's really more about, I think correspondence people receive, is probably the biggest thing for board members. Because you don't have staff, you're not gonna have volume of records, that the town is gonna have. For the last thing, I swear, last slide, this is just to give you an idea, we talked about, attorney-client privilege. These are just some of the other exemptions that apply to, records under FOI, meaning if something falls under one of these categories, even if somebody requests it, and even if it's a public record, it doesn't necessarily have to be provided. We talked about the personal notes under preliminary drafts and notes. That also could apply to like drafts of certain documents, depending on on what it is, you know, as a board member, you might receive the, you know, maybe there's a draft of something that is not, you know, the final version that's gonna be, you know, voted on or discussed or something potentially. But generally, once things go, you know, once they go on the agenda of a meeting, it's probably, you know, ready for action, it's probably gonna be something that would need to be disclosed. The last one on there, I think is also important, RFPs, I get questions about this sometimes. There is an exemption for responses to bid solicitations and RFPs until a contract is awarded, and that does a couple of things. One is, if we think back to executive session, the last reason under there, it said documents exempt under FOI. So based on that exemption, it means you can go into an executive session to discuss an RFP or a bid before the contract has been awarded. So you could review bid documents in an executive session if you wanted to, because they're exempt until the contract is awarded. Once you vote to approve the contract, you award the work to somebody, then everything becomes public and the discussions would have to happen in public. But it's a way that you can sort of do, you know, review those or negotiate, you know, it allows for that to happen before the contract is awarded.
Not really a FOI necessarily, but do we make bids public after that?
After
In
the
any
contract is
way?
awarded.
And yeah, like, I mean, do we post it? bids
So,
on-
you don't have to, you know, it's up to you kind of how you do it, but they would be public records under FOI. The only exception to that, I think it's further up on there, there is an exemption for trade secrets. So sometimes, even after a job is awarded, the other people that bid, certain elements of that bid might be, you know, if it's proprietary information, it might be exempted as a trade secret. But generally, if people request the bids and the contract has already been awarded, they would be able to get not just the person who got the job, but to get everybody who put in for it.
Get that all the time.
Yeah, I would think the contractors would want to know who they lost to and where.
Yeah, exactly,
For the other.
and the thing with trade secrets is that, you know, obviously you make the judgment about what is a trade secret, but a lot of times you know, if they're doing their job correctly, the people who are bidding are gonna kind of, you know, say that this is trade secret or confidential or proprietary or whatever. You know, if they don't put anything on there like that, then I would say, you know, you just send out whatever you receive, because you can't claim it as a trade secret on their behalf if they're not
Right.
at least trying to point you in that direction, right? You know, you're not an expert necessarily on all that, so.
So kind of a question related to that. Is there any way that it's allowable to provide access to the materials, not provide copies, and meet the FOI obligation?
I wouldn't think, if somebody requested copies, I wouldn't think so. There are certain, it's only like there's a few different statutes that operate that way, but it's like very specific things. Like there's one, like with the Department of Public Health and some investigations where they'll let you come in and look at them, but you can't make copies. But generally, if it's a public record, somebody can request copies, they can request to come in and review it. I don't think there would be, do you have an example in mind?
Well, I'll make up a silly one, just to have a silly example. But if you get some sort of say for example, you're looking at a construction site,
Mhm.
or you're looking at something that might have a stack of documentation this high, which may be thousands of pages,
Yep.
which if you were going to have to, if you needed to replicate that, was gonna take a lot of time and a lot of money. And, I mean, you could probably make them go away by saying, yeah, it's gonna cost you $1 a page, it's 1,000.
Yeah, but that could be, I mean, you can create a PDF.
You'd still have to scan.
Oh, no, I know,
1,000
I
pages
Yeah,
understand.
by doing
so
it.
two,
Where
yeah,
if you made it available and said.
they could just come
"Here
in
it
and look
is.
at it and they
Here
can
it
figure
is,
out what they
go
want,
ahead and
yeah.
look at it, find what you need.
So a couple things on that, I'll just say quickly. One is, if something is in hard copy form, you don't have to scan it to respond to an FOI request. So if it's a if it's a physical file in the building department, the options are the person can come in or you can make photocopies and they pay 50 cents a page. So if it's, you never have to digitize under FOI. If you have it available digitally and they want you to email it to them, then there's no cost for that. But if it's paper, you make photocopies, 50 cents a page. So the example you said, you could say, hey, it's 1,000 pages, you know, do you want to come down here and look through it? Or otherwise, it's going to be $500. And if it costs more than $10, you're allowed to ask for prepayment. So that's a way to try to avoid doing all that labor. And then the person says, wait a minute, it costs all this money and I don't want this and that sort of thing. So if you get a request like that, you can always contact me because there's, there's some tricks of sort of, if you know how the law operates, you can operate within the law, but you can also make sure you're not doing all this unnecessary, unneeded work. One thing I always tell people, if you get a really large request and it's from some kind of out-of-state firm or something that you're not familiar with, just try like responding to them and asking them some clarifying questions, and sometimes they might not even ever write back to you because they're just firing these out to every town, and if the suckers in Westbrook are just sending them all the stuff, then they great, but they're not actually gonna, they might not even engage with you, right? They might just, so you might just say, hey, I've got a couple questions about this, can you call me? And they never call you and they never follow up.
See a lot of that around the election time, and the registrars get stuff like
Yeah,
that.
yeah, and also the other thing with responding to FOI requests is that, you can't generally charge for the time, and that's frustrating, it takes time and labor, and, it's a sort of another unfunded mandate, we might say. But I think it's important to know, like, there are ways to sort of deal with those difficult requests, and also it's about a balance of all your obligations. So if you're a volunteer on a board and commission, you've got your family, you've got your job, you've got the work on the board and commission. If somebody sends you a large FOI request, you're gonna have a little bit of limited time to do something like that, and the standard for production of documents is promptness, and it takes into account all those different factors. So if you get a large request, it's not like we're expecting you to be up until 3 AM every night going through your emails, you would have to try to, do a little bit as you can. Maybe you're sending the person stuff, every week or so, a couple, on a rolling basis or something like that. So that's really everything I wanted to cover. I think this is the most important stuff for you all to know on boards and commissions. I'll check online in a second to see if anyone has any other questions, but does anyone in the room have any other questions? Anything we covered, anything we didn't cover? Can your cell phone be part of an FOI, particularly if you are seen using the phone during a meeting? This comes up from time to time, and what I'll say is, somebody could make a request for records, and they could make a request, and I've seen this, I want the text messages that were sent between, the meeting 7 o'clock and 8:30 on, Thursday night during the Board of Selectmen meeting. If the messages don't pertain to public business, then they don't need to be disclosed. If your spouse is texting you to pick up milk on the way home or something, that's not a public record. But if you're texting with your fellow board member, oh my God, what is this guy talking about? He doesn't know what he's saying, and oh my God, this developer, what a jerk. If you're texting fellow board members during a meeting, those are public records. So, it's not a text message to your board member during the meeting, it's not a secret little conversation that the two of you are having. Somebody can make those requests, and I think sometimes people do it if they see people on their phones during the meeting. So I think if you can limit the phone use, I know sometimes we have kids and things and we gotta check and all that, and I understand that. But if they see you just sitting there texting the whole time, and even some I've seen where, they hear the ding on the other end, like it's like you could tell. One's texting the ding and then the other one ding, like so, something like that, somebody could make an FOI request for those messages, and if it pertained to the board business or pertained to what was going on at the board, that, and again, it's pretty broad, like one of the last things I'll say pertaining to a board or commission, there was a planning and zoning meeting in the town of Bethel, and they took an intermission in the meeting. Well, the recording was still going and the microphones were live, and during the intermission, a couple members of the commission said some not too nice things about the developer who was speaking. And because the people online could hear it, the people in the room, including the developer, had no idea. So somebody online told the developer, hey, they were talking about you during the break, and then some of it got picked up on the mic. And the developer requested the full recording of the meeting because they recorded it on Zoom. And, at first they clipped out the part where during the intermission, and I said, this is the meeting. And he said, no, I want the full recording. I want including the whole meeting, not including the intermission. So they kind of knew that he was onto them, and they put up a fight and wouldn't give it to him. But ultimately the commission ruled that, that was a public meeting. It was being recorded. They were commission members. They were talking about the developer, even though it wasn't, during the meeting. The record was the recording of the meeting. So it ended up that, that got disclosed, and that was a very embarrassing situation for them. So, be careful about things like that too, that you're, if you're talking about, the business of the board, that's a public thing.
So kind of related to that, typically when we post the recordings of the meeting, make it a point to make it gavel to gavel. Meeting starts, meeting adjourns. and make sure whatever chatter may have been going on inside the room is clipped. Because it's not officially part of
Yeah,
it.
so that's okay what you post. The issue here was they had the full recording still.
So, yeah,
So they posted the edited version and they gave that initially to the developer, but they had the full thing. So that was the problem in that one, was that they had the full version. And, you know, I guess good for them that they didn't, you know, somebody was smart to not delete it, because if you delete a record that's been requested, you know, that's a violation. So they had the full recording of the meeting and, you know, they tried to argue, well, it wasn't during the meeting, so it's not a public record, but the comments were about the developer, so that was the key thing. Anyone else have any questions? Anyone online? No? Please call or email if you have follow-ups, if there's other things that come up. You know, I really try to be accessible to people. I try to get back to people quickly. Because I know sometimes, you know, you've got somebody breathing down your neck about, you know, you need to make a decision about something. So, you know, you do your business in public, you're not sending, you know, sort of snide emails back and forth, you know, you shouldn't have anything to worry about. And I'm always available if you need anything else.
Russell,
You mentioned something before, if a party makes a claim that they wanna know about a discussion between two people
Mhm.
that isn't written down.
Then there's no, you would say there's no responsive records, you know, there's
So there's no he said, she said.
no.
Okay.
I mean, if there's no records, there's no records. If something was a phone call, there might not be any records to memorialize it, so.
Okay.
You don't have to create any record.
Yeah, you don't have to create a record, so if somebody, yeah, you don't have to create a transcript of your phone call or write down what was said, yeah, you don't have to create records under FOI, it's just whatever you have available, you know, that you are, you know, is within your sort of, your purview, your universe of records.
Just as an example, if someone filed let's say I'm a member of, I have to be a member of Inland Wetlands, if they send me a request for all of the records that I have about a particular application. Okay, and all those, all the records I have are everything that's posted on the commission's website that I had to review. I could just tell them that, right?
Yeah, I think you could just direct them to that and say,
Okay.
you know, this is, yeah, these are all the,
As opposed to any
I haven't
individual
received,
things.
I haven't received any
I
records.
haven't created it.
Yeah,
We
exactly.
do that all the time. We say, here, that is under the finance department, under 2025 budget, there it is. I mean, and that usually satisfies it. You know, I've been 14 years now, in this office, and the FOI commission has been outstanding in terms of responsiveness. Your predecessor was awesome.
Tom Henning.
Tom Henning, yeah, was awesome. He came down several times. Russell, you were great setting this up right away. Appreciate your time very much. On a beautiful night. But thanks for coming to Old Saybrook. And honestly, anybody have any questions? I know Susan a month ago came to me and said, hey, you know, maybe a refresher would be good. And so this is why we're doing this. And it is good to do it
Yeah.
periodically.
It is.
So if anybody has any questions for any commissions, you can call them. If you want to contact me, I'm happy to relay it, but I find that commission to be just, hey, you guys pick up the phone and you answer the question.
Yeah, it's kind of embarrassing, but I get so many people and they're like, oh my God, I called the state employee, and like, they picked up the phone, and I was like, well, my job is to pick up the phone.
It's so true.
Yeah, cause I get a lot of calls from people, you know, we're preparing the agenda of the meetings tomorrow, you know, you gotta, so if you. I'm out a lot, you know, doing stuff, so if it's really, you know, you can always send me an email too, cause sometimes I see those first. But I try to be responsive, cause I know a lot of times you guys are trying to make these decisions, and, you know, I should have said this at the beginning, I'm not an attorney. My background's in journalism, I know most of the people that do this work are not attorneys either. So, you know, but I wanna give you that comfort level. You know, and I'm also, the other thing I'll say is I'm happy to, you know, if you need me to write something to you, you know, that you wanna share with people, you could contact me and I can, you know, do a little research and send you stuff. Because sometimes, you know, there might be people out there who, you know, you're gonna say, look, this is what the training said, and they're gonna say, no, this is what we're doing, and, you know, you've gotta rein in your board members or whatever, so I'm happy to try to, you know, share information that you can use to try to help, so.
Can we get your slide
Thank you
deck?
for allowing us to
Sorry?
put this on recording, so.
Oh,
that
yeah,
we can
definitely.
Refer it, it's quite intensive,
And
really.
the slide deck,
Oh, yeah, you have it, I think,
okay, I have it.
alright,
If
I
have
think
it-
I emailed it to you,
Can-
but.
Freedom,
I think
FOIA, I'll
Yeah,
put
You
a
could
FOIA
FOI,
request
you
for
could
that.
FOI.
Right, better run, because
Okay.
thank you. All right, thank you.
Take care.